Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. And guess what today is? It's Saturday. And if it's Saturday, that means it's our Crime Talk weekly recap of all of the top stories. Hope you watch it and enjoy. Another hearing in the Lori Vallow Chad Day Bellmatter today. We brought it to you live. We always try to do that because we love our subscribers. Now, the first part, it's a little boring, and hopefully Frank, the hardest working man in show business, can maybe chop that out of the live and get to the real meat of it. What was the meat of the hearing today? Nothing regarding protective orders, and the court only addressed the motion regarding Prohoc Vice. And that is a request to have an attorney from another jurisdiction be admitted in the state of Idaho so that she can help. That attorney is an attorney by the name of Rachel Smith. Now, she used to be a prosecutor. Apparently, she's been involved in lots of complex fed prosecutions throughout her years. And she now has a consulting business. It sounds like she's been hired to be a special prosecutor in private practice, and she has a small civil practice, according to her own words today here in court. She was there alongside Mr. Wood. Now, why does Mr. Wood need another special prosecutor? Well, I went and looked at it. The Madison County District Attorney's Office has two prosecutors, Mr. Wood and one other attorney, and two support staff. This case is a full-time job just going through the discovery. Little surprising that apparently there are no other qualified attorneys in the entire state of Idaho that are available to come work on this case, that they had to find somebody who has a private consulting gig in Missouri. The second thing is, and I'm sure it's a little humbling for Mr. Wood, is to basically say that I need to bring in help for this particular case because it's very too complex. Lots of issues regarding cell phone records. Lots of issues going to be regarding kind of tying everything together to make the allegations stick if the prosecution is able to do so. Now, in this particular case, Mr. Pryor objected, kind of. He didn't really get an opportunity to do so because the court had issues regarding the Prohoc Vice matter. First, the court was concerned about saying, hey, you're a special prosecutor from Fremont County. Don't you have to get the approval of the Fremont County District Attorney and or the Board of County Commissioners to pay for this? Mr. Wood said, well, Judge, my office is paying for it. We're not asking for money, so I don't need their help in any way. Mr. Wood also noted that, Judge, if she's admitted Prohoc Vice, then I can swear her in as a special deputy, and therefore she then has all the power and authority as a district attorney. The judge seemed to be satisfied by that, also with the fact that she has a private practice. Clearly, the court has read the rule and was dotting his I's and crossing his T's. Why is the judge being so thorough? It's a high-profile case. No judge wants the case to come back on an error or mistake that they made. And could you imagine if this case went through, Pryor or Means object to a special prosecutor, then it turns out they were not duly appointed correctly? Oops, can't have somebody in there practicing law who shouldn't be. So we'll see how that goes. We'll see what Miss Rachel Smith is going to do for this case. She's basically admitted, and they set another motions hearing date on April 7th. So we'll see what motions that the defense can come up with here shortly. Obviously, we still have the whole issue regarding the protective order that somehow is so secretive, not even the prosecutor's going to get to know what it is just yet. Court didn't take that up. I wish they would just settle for a date and resolve all these motions here early. We have a trial date in July. I somehow have a feeling things are not going to go as planned at the pace that we're going because it takes forever to get something resolved. The court should set a deadline for all of the motions to be filed. Speak by that date or forever hold your peace unless it's a constitutional motion. Have a hearing date and let's get to trial. This piecemeal nitpick set a motions hearing date 2 weeks after you set a hearing to set another date is getting a little slow. Boring is another word that comes to mind. So we'll see how things develop and we'll be there. And yet again, that's right, it's coming from the Lori Vallow Chad Day Bellmatter. As you may recall, there was a hearing yesterday that only dealt with the issues regarding the Prohoc Vice admission of the new special prosecutor that Prosecutor Wood wants to hire or may have already hired and would like to have her admitted to prosecute the case. They only went forward yesterday as it related to Chad Day Bell's matter. And miraculously, a motion was filed, an objection was filed by Mr. Means on behalf of Lori Vallow late yesterday. And boy, is this going to make you chuckle. All right, let's get to it. Let's explain what's going on. First, do you recall a couple of weeks ago, the defense on behalf of Lori Vallow filed a motion for specific discovery? Basically, it's a request saying, we demand the state turn this information over. Specifically, this was the motion, specific request for discovery pursuant to Idaho Rules of Criminal Procedure, Rule 16. It was filed March 8th. And in that request, the defense wants a list of all the deputies, the authorities and or jailers for the Madison Sheriff's Department, Madison County Detention Center, Rexburg Police, Madison County Prosecutor's Office, or any other agencies identified as authorities of jailers, including but not limited to the full name, specific title of employment of said authorities. Include their full name, date and time of conversation, specific statements of anybody regarding any conversations involved this case. And then finally, the request include, please produce all records, tangible said communications, comments, tangible or intangible, included but not limited to reports, recordings, text messages, emails, phone records, voicemails, pictures, videos, and or the alike. Whew. Sounds so lawyerly-like, doesn't it? That's right. You always got to include everything in there so that somebody said, well, you didn't mention that. So you got to include it all. Well, the prosecutor responded. Their response, and I hate to do, and I'm a defense guy, right? I'm a defense attorney. You want the defense to be like, yeah, kind of sticking it to the man, but I just haven't seen any of that thus far. The prosecutor's response is simple and straightforward. Prosecutor responds in their motion that was filed on March 22nd at 4:59 p.m. The state objects to requests 1, 2, and 3 of the defendant's special request on the following grounds. 1, outside the scope of Rule 16, right? Rule 16 says you have to turn over everything related to the case in your possession. Prosecutor says nothing in Rule 16 would require the disclosure of the requested information. Second, the request would require the state to perform the defense investigation and collect the evidence the defense should collect for itself. And I hate to say it, but he's right. I'm a defense guy, right? I mean, I've filed these motions occasionally to say, hey, I want this, this, and this. And sometimes they go get it, and sometimes they don't. But really, these are all things that the defense could go and get on their own. It's called the power of the subpoena. You simply go, as an attorney, you issue the subpoena, you write up what you want, you serve it on them, you serve it on the prosecutor. If the person that is objecting to producing the documents or the information objects, they file a motion to quash and you set a hearing. If they're going to produce it, but you still set a court date for a return date on the subpoena, and there you go. It's not the prosecutor's job to go get this information so that the defense can litigate these collateral issues as to whether Ms. Vallow is being treated unfairly because she cannot see her attorney, according to her defense attorney, at times that he wants to see her. So I think when this is all heard on April 4th, I believe is the next hearing date, guess what? My prediction, is that the defense request for all that information to be turned over is denied. So now, yesterday there was the motion regarding the admission of Rachel Smith. She is the Missouri attorney who used to be a former prosecutor and now basically has her own private practice with a very limited civil case, but apparently is retained as a special prosecutor in various jurisdictions. Mr. Wood wants to bring her on, and basically the court allowed that to go through. There was an objection made yesterday by Mr. Pryor, the attorney for Chad Daybell. Additionally, the court made some inquiry as to whether there was in fact jurisdiction. But since Mr. Wood stated that, hey, we're not asking for the county, Fremont County, to pay for Madison County's fees related to hiring Ms. Smith, it's not really an issue. And Judge, they would have the authority to practice if they are sworn as a special deputy district attorney. It doesn't matter who's paying for that particular situation. As I stated yesterday, and I wasn't knocking Mr. Wood, but it's kind of humbling. I mean, sometimes you have to admit, hey, we just don't have the resources or the experience to handle a case with this amount of large discovery. And if you don't do it on a routine basis, you simply don't have the infrastructure to handle those type of cases. All right. If a huge racketeering case comes in, we're set up for it. We have the attorneys. We have all those types of necessary equipment that you're going to need to go through the discovery, to index it, to sort it, to search it. And if you don't have one of those cases, you need more than just a little old laptop to get through that. It's just, it can't be done. So at least Mr. Wood recognized, hey, we need some help here. I've never knocked Mr. Wood. I think he's a fine attorney. I have no reason to doubt it. It's a little humbling to say I need help. However, it's also a good sign that you're a humble person and you think, hey, let's bring somebody in that's done cases like this and let's go forward. So Mr. Means has filed an objection. First, he says, quote, barred from hearing motion. The motion is barred, in parens suspended, from hearing as a result of previous court orders. Doesn't make any sense to me. I'm not sure which previous court order. Then saying the court lacks jurisdiction, saying the plaintiff, it's not the plaintiff, it's the people, the prosecutors attempting to put the cart before the horse. No charges other than those presently before the court are subject to this court's jurisdiction and review when considering this motion. Court consideration of published, quote, threatened, end quote, future charges are not before this court and therefore not grounds for granting this motion. In summary, the prosecution has clearly placed the cart before the horse and as such is asking for speculation by this court to justify this motion. This matter is concealment/conspiracy to conceal case and nothing more. Consideration of non-existent charges would be improper and an abuse of discretion. The current charges are not presented as expertise of Ms. Smith. Now, I can honestly tell you, I've never had anyone object to an admission for Prohoc Vice. When I've been retained or even as CJA counsel in another jurisdiction, nobody objected to someone's admission. And I'm not really sure, but basically saying this case isn't that complex. Why would Mr. Wood need help? It's not really for the defense. The prosecution has unlimited resources. And if they want to bring on a team of attorneys, they can do that. So I'm not really sure I understand that particular argument by Mr. Means. And then Mr. Means goes on and said he waived righted. Waived righted. Never heard that term. Prosecutor Rob Wood is the public prosecutor of Madison County, state of Idaho. He is elected and obligated to perform prosecution of, quote, crimes, end quote, as his duty. Said prosecutor filed with the court his motion to be appointed as special prosecutor for this case outside of Madison County, state of Idaho. At the time he filed said motion, he was aware of his staff and office capabilities, again prior to appointment as special prosecutor. He has waived any motion for additional retention of counsel in this matter by asserting his capabilities to handle said matter. Put aside the tremendous financial cost to the county and state, Mr. Wood represented to the court that he and Madison County could prosecute this case without bringing in a pitch hitter to do his elected job. basically goes on and says it just can't believe that he can't prosecute this office. And as a member of the citizen, he is outraged at the expense of bringing in somebody else. I'm a little surprised that there's no other prosecutor in the state of Idaho that would be qualified to do this particular position. But hey, that's the prerogative of Mr. Wood. If he wanted to hire a team of attorneys, he could do so. Now, let me tell you a little story. When I was a young lad and I was a prosecutor in the military, there was this case and all the witnesses had scattered literally around the world because we were at the Parris Island Recruit Depot where the court-martial was taking place, and literally the witnesses had scattered all over the world. And I went to the convening authority, who was a colonel at the time, and said, sir, this is going to take a lot of money to bring all these people back. It's coming out of your budget. Is this really worth going forward on, et cetera, making all the arguments that you make when you're advising the convening authority. And the colonel looked at me and said, Captain, there's always money for justice. And that was it. And that's what we had to do. We flew in everybody from around the country to prosecute the defendant in that particular case, from around the world, I should say. We flew everybody in from around the world to prosecute that case because justice is expensive. And that resonated with me because every time you have a case and you think we're going to break the bank on the prosecution, they'll never be able to prosecute this case. Witnesses are over. It's too expensive. They always find the money. Just like in this particular case, Mr. Wood found the money to bring in somebody to assist with this case. Bottom line, it's his office, it's his money, he can do it. Frankly, these objections to a prosecutor coming in, Prohoc Vice, is frankly ridiculous. If it was just a prosecutor that was hired from already working in the state of Idaho, they couldn't be upset in any way whatsoever. I can't believe they tried to make these arguments with a straight face. But hey, just calling it the way I see it. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. All right, next on the docket, the Boulder shooter. Yesterday, we reported to you that the suspect, Ahmad Al-Ali Alissa, was charged with 10 counts of first-degree murder over a shooting at an Area King superstore just down the street here near Boulder, Colorado. According to the brother, Alissa reportedly suffered from mental health issues. In fact, he was quite concerned and paranoid that he was being followed. Well, it turns out he may have been being followed, that is, by the FBI. Apparently, they were, in fact, watching him and didn't see any issues until perhaps he went to a Boulder store and shot and killed 10 people. We're also finding out that he is apparently very pro-ISIS. He hated Donald Trump and was becoming more and more devout Muslim. Certainly nothing wrong with that. You just can't go kill people for that reason. We're obviously going to have to wait for more information to come out as this story develops to see really what the truth is, but that's the information that was coming from his Facebook account. Now, we can't go back and see his Facebook account because Facebook took it down, but I'm sure the authorities have that in their possession, or at least the digital record of it by now. We'll continue to follow the story. Absolute senseless tragedy, that's for sure. Tammy Daybell's sister, her name is Samantha Gwilliam, and her husband, Jason. They're speaking exclusively for the first time, and the interview will be aired this Friday night on Dateline. It's a 2-hour special. Gwilym tells NBC that Chad told her Tammy had been, quote, been sick and had a coughing fit and passed away, end quote, adding that Chad sounded upset and devastated. I mean, he was crying and he was crying, and it was just a really hard moment for everyone. And then they found out that Chad married Lori Vallow in Hawaii less than a month after Tammy's death. The Gwylyms have never met Lori and were stunned at the news. She was shocked at this point, saying she hasn't even been gone a month. Is the grief clouding his judgment? Oh, I think something was clouding his judgment. Yeah, it was Lori Vallow rocking his world. I think that's what was clouding his judgment. Needless to say, Tammy's sister is upset and shocked that her sister is gone, and obviously very upset that Chad remarried so quickly. There's also going to be some information that basically these children, JJ and Ty Lee, would still be around if the court had listened over a decade ago and not let Lori have access to these children. Ought to be interesting. Hope you'll watch it. I certainly will be. Lori Vallow. The court has signed the order and is allowing Rachel Smith to appear Prohoc Vice because she is not licensed in the great state of Idaho, and she will be deputized as a deputy prosecuting attorney to serve as local counsel. What does this mean, if anything? Well, I don't know. I did some research on Rachel Smith. She basically looks like a career prosecutor, resigned when a new district attorney came into power there in Missouri, and did some teaching for district attorneys. Clearly never done any defense work, at least from what I can tell. And according to her, she does a little bit of civil litigation, as well as being a prosecutor, as a special prosecutor in Missouri. I could not find any particularly interesting case that she was involved with or any great skill. She's a career prosecutor, but the prosecution should bring on whatever resources they need, because what is the prosecutor's goal in any case? Justice. That's it. Not to get convictions, it's justice. Although I do always say, if you want justice, don't go to a courthouse. You may not get it. But hopefully in this case, we do get justice for Ty Lee and JJ. All right. Thanks for watching. We'll see you next time on Crime Talk.